And then we're going to share a screen. I think is this one. Can everybody see my screen?
Yes.
Okay.
Yeah.
Well, that one's pending. I don't want that. I'm just trying to find a good new listing to work on here with this so we can, oh geez, everything's pending. Awesome.
I swear that's how it is every time I look. Everything's pending.
And I wish I had my listing out there for you, but we're not ready yet.
Pending. Well, this isn't going to matter. So, all right, we're just going to work with this one. I could spend all day looking for stuff. So, all right. So when we go into Dotloop, you'll kind of see kind of a home screen here, and there's different ways you can configure this. And so I don't want you to get hung up on this per se, but just when we start a loop, like, okay, so this property is, everybody can see my screen switching, right? Back between us and okay. So 380 Rains Drive in Caledonia. Oops, I think I just closed out of that. Awesome. We can do this here. Now, if we're the buyer's agent and it doesn't find any results for me, but let me go back in and log back into the MLS here. Not seeing it. It should import some info in here. That's why I was trying to find a good listing that would work. Maybe because it's pending. Maybe that's why it's not finding it. All right, so we're gonna shift on the fly here. I know one. I've got it pulled up over here. It's 8915 Barrington. All right, I'm being really dumb. We need to hit the add a loop button first. This is why I'm not a tech trainer, guys. I can teach contract, but
I'm still on the MLS page for 380 Rains.
oh, that's what you're seeing?
Yep.
Yeah.
Yeah, same.
Okay. Let's try this again. How about now?
There you go. Okay.
Okay, so we can see I'm going to select a new loop. I hit this blue button that said add a loop. So we're opening, you can open a listing or a buyer side on this. And so we're going to want the purchase template. You can upload a photo. I don't typically do that. You may want to put client's name in there. Keep it straight, especially if it's like a listing on our team. And guys, this is team oriented. Eric, don't mean to cut you out of this, but
No, I'm just happy
listing
to.
and you're writing an offer on our listing and you want 2 loops going, you may want to put your buyer's name in there too.
Okay.
So we've got a purchase template that'll pull up all of our buyer documents in there. And again, you can upload a photo if you want. It's going to create the loop. I'm going to hit view loop. and I've got all my documents waiting here to use. Now, I'm going to reorder these for us because I think, I'm a little old school in that I like to present documents virtually like I would present them to a buyer if we were sitting down at the table. And so this hasn't been real high on my priority list, but I do want to start thinking that way. And eventually when we get into command with DocuSign, I think we'll probably have a different order to these. But so any conversation we learned early on in real estate licensing class, that the disclosure regarding real estate agency relationship should be presented at the time that you first meet with a potential client. So here I'm going to back out of this a second and show you, we got to add a person in here. I've got to add a buyer just to make this work right. So you're going to add your buyer down here. Bethany, I think you're already in here, so no. I'm going to add you as my buyer on this.
Okay.
Let's see, I know I have your email address. It's just, are you Bethany Stebbins at KW or?
I think it's just B Stebbins.
Oh, that's right. Yeah. And then you pick the role of the buyer, seller, or whoever. This instance, now don't add them to your team unless it's somebody on your real estate team. So you're adding me to a loop if we're doing a deal together. You're adding Kelsey if she's the transaction coordinator. But for your clients, don't check that add box because they'll have full edit capability in here and you don't want that. So we're gonna add Bethany here. We know that initially we should get this signed at the time we meet with them. That's kind of state law. I can tell you this from a real world application, people are averse to signing things. Like you're not going to whip this out at an open house and go, here, I need you to sign this. If you're trying to pitch your services for them to work with you as a buyer's agent. So what I tell people is there's an appropriate time to get everything signed. And there's a necessary time to get a lot of things signed. So but the first document we want to go over with them is the disclosure regarding real estate agency relationships. And so what this does is it's simply a disclosure that lets a client know who we can represent and how we can represent them, and sets forth kind of an action plan moving forward off of that. And it's also a disclosure saying they aren't working with anybody. And so if you have this signed, had this happen last week, I had a buyer's agent call me and say, hey, I've got those people you're working with under contract. And I was like, well, they signed a disclosure statement. I could have really fought it, but I wasn't going to. And at least you've got documents signed that they're indicating they aren't working with anybody. So they've changed this form up over the years. I used to have a really good script for this. It doesn't really work with this the way it reads now, but you can start by saying, as of January 1st, 1994, which goes back almost 30 years now, the state of Michigan defined buyer agency and also now seller agency, and then created the possibility for dual agency. And so whether I represent a buyer or seller or both, I have certain duties and responsibilities to those clients. And as a buyer's agent, I can't reveal their motivation for buying. They have to keep things confidential, disclose to them anything I know about the house, the seller's willingness to accept a higher or different price, and or anything I know about the real estate market in general. And I always gave this example. This was real world for me. There's a golf course, it used to be down on 44th Street in Kentwood, and there was a housing development behind it or beside it. And I was out there showing houses one day. Well, I'd read in the newspaper, yes, this was that long ago when we still had newspapers, that the golf course had sold to a housing developer, and sure enough, today it is a housing development. But we went and looked at a golf course frontage house in that neighborhood next to it, and I had to tell them, look, you may like this house, but a year from now, you're not going to be living on a golf course. And so we have a duty to we don't have to know everything, but if we know something, then we have to disclose that to a buyer as well. So if you know, like a strip mall is going up next to a house where there's a vacant field, you should always disclose that information. So, so we can represent a buyer, a seller, and both parties with disclosure, and sometimes as a transaction coordinator. So this first paragraph up here, number 1, says an agent providing services under any service provision agreement owes at minimum the following duties to a client. This is like state law minimum, right? Reasonable care and skill in representing the client and carrying out the responsibilities of the agency relationship, performance of the terms of the service provision agreement, loyalty to the interest of the client, compliance with the laws, rules, and regulations of the state and any applicable federal statutes or regulations, referral of the client to other licensed professionals for expert advice related to matters that are not within the expertise of the licensed agent, and accounting in a timely manner of all money and property received by the agent, which client has or may have an interest, and confidentiality of all information obtained within the course of the agency relationship, unless disclosed with the client's permission. So then the second paragraph says a real estate broker or salesperson acting pursuant to a service provision agreement shall provide the following services to his or her client. When the real estate broker, real estate salesperson is representing a seller or lessor, the marketing of the client's property in the manner agreed upon in the service provision agreement. So this is where things have changed. We always used to be all full service, and now they can have different services available, like an MLS only access listing client, or it's hard to do a limited service buyer agency agreement, but I suppose that could possibly exist too. Acceptance and delivery of presentation of offers, assistance in developing, communicating, negotiating, and presenting offers, counter offers, and related documents. After execution of a purchase agreement by all parties, assistance as necessary to complete the transaction under the terms specified in the purchase agreement. And for a broker, associate broker who's involved at the closing of a real estate or business opportunity transaction, furnishing or causing to be furnished to the buyer and seller, complete and detailed closing statement signed by the broker or associate broker. So don't let that one weigh you down. Title companies prepare closing statements, so you don't really have to worry about that, but it should be included in what you do. So a seller's agent is under a listing agreement with the seller, acts on behalf of the seller. Now, again, I'm 10 minutes into this and reading a lot of fine print. And again, if you're sitting down with a client going over this, that's great. If you're on the phone explaining to them while they're looking on Dotloop, you can give them the high points of this and explain, hey, look, I can represent you as a seller, represent you as a buyer, represent both with disclosed dual agency, and act as a transaction coordinator. So we're going to select one of these. In this case, since we're doing buyer docs, I'm going to select buyer's agent or sub agent. Like I said, I don't know how we do a limited service agreement buyer agency contract. I've never seen one. I don't get it, but it's on there. So now, does anybody remember what designated agency means? And since we're in the world of Zoom and I can't see your faces because I'm looking at my screen, I'll assume that is a resounding no. So not a problem. Designated agency is a type of agency that we select as a brokerage at the state level. So what that means is, because we've got 250 agents in our office here, plus that we are a designated agency company. And so Bethany, it could be your listing. John, it could be your buyer. And if we were not a designated agency, we would be in dual agency because it's all under the brokerage. With designated agency, Bethany, you represent your client. John, you represent yours. And so there's still that separation of agency there. So the best way to explain that to a client, if they ask, or when you're explaining this document to them, is to say, look, at the state level, we're considered designated agents. That means that anybody's listing from my company, I can still represent you as a buyer's agent. And that's how you kind of explain that to them. Affiliated license disclosure. So you'd check this one always, because we are a designated agency company. And then this one, presumably, if they do not have an agency relationship with any other real estate licensees. So now, there may be an inclination, there may be a circumstance where you would check this box. If somebody lives in Detroit and they've got their house listed for sale with another agent, you could add them to your buyer agency contract without violating any laws or code of ethics violations there. So the possibility does exist, but it's likely the main thing you want to remember is, have you asked, are they working with an agent if they're brand new to you? And if not, make sure that we check that box and have them sign that. So we're going to mark here that they're potential buyer. You've got 2 signature lines, providing if you've got Mr. and Mrs. with you, you can add signatures below this, but so I'm going to select, there we go. I'm going to select Bethany to sign here, and I can sign this live in person. If I assign it to myself, and drop down, go sign here. And we're signed. Now, a little pro tip on this, you're going to see this over here where it says signature. Just drop down and put no one in there. Make sure it says no one. Because if it says buyer sign here, they're going to sign in both places. And anywhere it says sign here on any of your documents, if you don't change it to not here, then your buyer is going to go through and sign everything. And then they're going to have signatures where they don't really need to be. So I'm not going to save and share this. I'm just going to save this for now. Any questions on agency disclosure?
I did have a question actually. I
Yeah.
wanted to ask when I got here.
John's in the room with me now, so I don't know if you hear him or not, but
So when I just purchased a house in Grand Rapids, right? And after we closed, my realtor sent me this document. He said, "Hey, can you sign this or whatever?" I'm like, yeah, sure, no problem. But technically, could I have said like, no, I'm not signing it, and he would have been kind of screwed out of everything, or did he screw up by doing that?
Yes and no. So every broker has different compliance regulations, and ours is you don't get paid until you turn in a complete file.
Okay.
So he missed it with you.
Right. And that's what he told me. He's like, you sign this right now. I want to get paid like tomorrow. You know what I mean, or whatever.
Technically, he was in violation of state law. If you really wanted to screw him to the wall, you could have turned him in, but nothing really would have happened to him.
Right.
I've had occasion where we've had that happen. Buyers agents miss something to sign. Doesn't really, I'll waive it on occasion.
Mm-hmm.
It usually means the client's really obstinate about something and you're not going to get a signature out of them anyway. And it's kind of a risk management thing at that point. But if you can't get a signature from somebody that's on something necessary, then come see me and we'll deal with it. So, but yeah, that's a good question. Yeah, you could have hung him up for a little bit if you wanted to.
What do you mean? Like they don't sign something they don't want, like a paint something? Home
warranties. We have a home warranty waiver form that we need to get signed that says if you're not purchasing the commercial home warranty, that at least it's been offered to you and you're waiving it.
Okay, right.
And that's probably the most common thing because it's the last thing we ever get signed. If you forget to sign at the closing, you go back after the closing and then they'll say, I'm not signing that.
Oh, I got you.
And so that's usually what I end up waiving. But if somebody refuses to sign this next document, the buyer agency contract, not going to happen.
Yeah,
so that legally means that they're being represented by you as a sub-agent of the seller. So if you're working for the seller at that point. So now we can add myself in here as the buyer's agent. The more info you add in here, it'll just auto-populate. I'm not going to add addresses or anything in here right now, but you can hit autofill. It'll add some of this in here. Dates are real easy to pop in. Now, typically we're going to sign these for 6 months. I saw one the other day from a different brokerage. Somebody had signed up for a year. You can sign a buyer agency contract per property if you want to. If somebody's really averse to signing this, explain to them, you say, hey, look, until we have this signed, I'm legally representing the seller as a sub-agent. It only changes the things that I still have to disclose material defects to the house to you, but I can't disclose what the other agent may tell me about their willingness to complete a sale. If you want me working for you, we need to sign. I can sign it for a couple weeks and see how it goes, and then we can amend it or sign a new one if you're averse to signing it right now. The goal is to get this signed when you start working with someone as a buyer, not when you write the offer. But I will tell you, present company included, a lot of times we fill these out when we write the offer. So
Right.
just remember to get it signed. It is going to protect you. So if you're out showing houses and they squirrel off down a different path and go to an open house and decide to write an offer, we don't know if that agent's representing the seller, but he may just want to double dip that deal. And he may say, hey, I can work with you on this deal, save you some money. Hey,
Does that happen often?
not a lot. I think we handled like 2 or 3 of those cases last year.
So I was like always under the impression of real estate, and it kind of, if someone comes to them and they're like, oh yeah, we were working with someone, they kind of back off, right? Like, well, I don't want to work with you, I don't want to ruin that relationship or whatever.
Our goal is to be as honest and forthright with everybody that we deal with. And but there are agents out there that will try and steal your clients. Our town is pretty good. I don't, a lot of times it's miscommunication. My incident on Friday, this was a guy I've known for probably 7-8 years, ridden bikes with him. And he was in a group message, and we were chatting, and he said he put an offer in on a house. And so I messaged him on the side. I said, hey, I'm happy for you. I hope you get it, but I'm kind of bummed you didn't call me. And he goes, well, it was just kind of a spur of the moment thing. And we didn't really think we were looking until we saw this one. We went and looked at it and liked it. And he didn't say anything about working with another agent. I just kind of figured he went through an open house,
Right.
Because if somebody says, hey, I would have called you, but then it kind of indicates that they probably would want to work with you. So we started chatting some more. I set up a search profile. Next thing you know, last week, I'm out on a Thursday afternoon showing him a house that he wants to write on. Well, we write an offer, submit it. And I get a call from this agent at another company. And she's like, these are my clients. And I was like, okay.
Oh, really? Okay.
Yeah. And I mean, I screwed up and I owned it. I said, look, I probably should have asked him a little bit further about the offer they did write. It's like Thursday afternoon, we're out flying to see a house and they like it, and I'm going to have an offer in by 4. I'm not really thinking, along those lines. If it was somebody from the general public calling and I wanted to pick them up as a buyer, I'm having that conversation. Hey, are you working with an agent? A lot of times they'll say, oh, we've been out to see a few things, but we haven't signed anything. These people didn't even know what they signed. Like,
I gotcha.
like
But they did sign.
They signed this
Okay.
along with the offer,
Right.
and they had no clue that they signed it. And she's an attorney. So don't ever trust any of your clients to read any of the things you send them on Dotloop, because they don't. They just point, click, and sign, and they're trusting you
Right.
that you're presenting it. So I always try and give a little synopsis of what people are signing in there too.
So like, how do you know if someone has an agent already? You just gotta ask them, and then it's like,
If you ask them and they say no, then you have to take them on their word, and they sign that agency
Okay.
disclosure statement that says, no, I'm not working with an agent. If you've got that signed, you've got this signed, and they've told you no, then there's not really much else you can do. And that's
Right.
typically, where the miscommunication happens and where trouble starts. I've had on occasion buyers, try and get ripped away from other agents and stuff, but for the most part, our community is pretty good around here. So
in that scenario you were in, what happened with that? Then did she end up getting?
well, we didn't get the house, and so I just
Okay.
turned it back over to her. I
Gotcha,
said, look,
gotcha.
I'm not going to step on your toes. Just go ahead and work with them.
So
So
what if they would have got the house under, right?
we would have had discussion.
Okay. Okay.
I was kind of dreading both scenarios, to be
Right.
honest with you, because I really wanted to, I wanted to knock the sale and get a listing out of it. They've got a house to sell, which I think I still get that listing, but it was an easier thing for me to just let it go and not
Yeah,
have to
yeah,
fight
I
through
gotcha.
it. So, but
In other words, don't make sure this is signed.
Yep. Purpose. Okay, so this is your buyer agency contract. This is what ties you to your buyer, and it does indicate that we're designated agents on this. And it's got a start date and an end date. I think I was talking while I did this, and I ended up putting in today's date on this one too. So every contract should have an end date. We'll run this a little over 6 months here. end of August. Bethany, don't sign this, otherwise you're my client.
Okay.
So our property is going to be buyer desires to purchase real property meeting the following criteria. Now, I keep this kind of vague. I usually put single family home in West Michigan here. Because I've had buyers, if you fill this out specific to Grand Rapids and they go to Holland and buy a house, then, technically, legally, they could get out of it and go buy a house with a Holland agent. I explain, and coincidentally, like I don't normally do this unless somebody's real specific about it. And this last one, I put the address of the property in there. So that buyer agency contract was only good on that house that I wrote on, which we didn't get. So it was an easy out. I didn't have to terminate the contract or anything. So brokerage firm shall assist buyer. I'm going to go back up here. Purpose. Brokerage firm shall assist buyer in purchasing real estate as more particularly described in paragraph 3, which we just filled out. Brokerage firm services shall include, but not be limited to, consulting with the buyer regarding the desirability of particular properties, availability of financing, formulating acquisition strategies, and negotiating purchase agreements. It's really the scope of what you do. Designate agency is explained here that it's the relationship with the agent, and only myself as the supervisory broker that you're in designate agency with. Our old broker added this in here about floodplain. I don't know, he's really got an interest in floodplain for some reason. If you want to direct your clients to this website, that's a good idea if you're near water, but at any point that's in there still. We may get that taken out of there at some point. So exclusive agent. Buyer agrees that during the term of this agreement, any and all inquiries and or negotiations on behalf of the buyer relating to the showing or acquisition of any desired property shall be through designated agent. So what I tell people is this: there's a chance that they may find a for sale by owner on Zillow. They may find a property driving by it for sale by owner, may hear about their uncle's house. You're still their agent on those properties once this is signed. And it is easier for us to make that call to a for sale by owner to set up a showing and ask about whether or not they're willing to pay a commission if that comes through us. And so what I tell people is this: look, if you see a for sale by owner, either online or in person, and call me with the address, contact me with the open house time or whatever you're going to go, and I'll try to be there. I'll make the contact with the people, say, hey, are you open to working with a broker? Most are at that point, but if you just send your buyer into for sale by owner open house, they get to talking, they've already got everything figured out. And then, oh, by the way, I'm here to write this and pay me 3% of the sale price. That's usually when they start pushing back a little bit. So compensation. I always tell people we are a for-profit entity. So compensation of the brokerage firm is detailed here. In consideration for the services, we know consideration means payment. Buyer agrees to pay the brokerage firm as follows. Now, this is where people freak out because we all hear that, hey, it doesn't cost you anything to use buyer's agent, right? Yeah. Well, it doesn't unless you're not being offered a commission, and we've agreed to get one paid here. Now, the thing you're going to want to pay attention to over the next few months here is there are going to be some changes with how commissions are disclosed to buyer's agents publicly and paid. There may come a day where you need to seek compensation from your buyer directly for a buyer agency contract. It's not the case right now, but so I don't work on a retainer fee. Very rarely would you work on a retainer fee in residential, but possibility exists. We typically put 3 to 3.5% in here of the purchase price for the commission. Now it says the commission is due and payable upon closing, provided, however, that if the transaction does not close because of the default on the part of the buyer, the commission shall become immediately due and payable. So again, your buyer walks at the last minute, you could be paid a commission. We're not, as a company in the business, of suing people to make commissions. I've had to threaten it before. We usually work things out. We're in this for referrals, and and longevity in this business. And if you get the reputation that, you're just going around suing people to make money, then it's never going to end well. So now, this goes on to say that the commission obligation shall apply to any purchase agreement executed during the term of the agreement or during any extension. The commission obligation will also apply to the purchase agreements executed within 6 months after the expiration or termination if the property acquired was presented and shown to the buyer during the term of this agreement. So let's say we're in month 5, show Bethany a house at 123 Main Street. She doesn't buy it, and a month goes by, she goes back to that seller and or the listing agent and says she wants to buy it. Well, we showed her the house. We had procuring cause at that point. We'd be due a commission. So buyer will receive a credit. This is number 6. Buyer will receive a credit against any amount owed pursuant to paragraph 5 above for any commission paid to the brokerage firm by the seller or the seller's listing broker. So this is where they're not paying out of pocket. We're offered a compensation on the MLS, typically 3%. Now, if you've got a differential of 2.5 being offered and 3% in your contract here, legally, you can go get the other 0.5% from the buyer. Again, I add language in the bottom of mine down here in the other section that says something to the effect of, in the event the property is listed, any commission paid by the listing broker will be considered payment in full. I know agents that go after the other 0.5%. Markets dictate commission sometimes, and I think we're in an environment where you're going to start seeing more 2.5. Our company policy is we offer 3 to a buyer's agent, unless it's $1 million or more, or commercial property that can change things a little bit, but or bank owned where they stipulate that you have to offer 2.5%. But typically with our regular residential real estate, you have to offer 3% on a listing. It's our company policy. If you're taking the listing at 5 with our blessing and Judy's or mine's okay on it, then we're going to take 2% on the list side and you'll still offer 3. Again, that's going to change, I think, at some point, but we'll see. Disclosure of the broker's role. And again, I mean, if you're sitting down, this is going to be something where it takes 2 minutes to get this signed. I'm doing a deep dive for explanation with you guys.
Yeah.
If you're going through and explaining this, I mean, again, you can sit here and read everything to your clients. Some people like that. Some people like to read everything. They're going to they may come back with questions, but really, this is, you're going to learn some table talk language of, hey, this is how we present this, and it's going to get smoother for you over time. And I'm out of practice with it. I just don't do it enough anymore, but I could usually have this down to about 2 minutes or less. So, so the broker's role, again, bold print, designate agent, supervisory broker will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. So if let's say I've got a house that was listed and it expired, and then Bethany comes to me and wants to buy that house, I still have to preserve any confidentiality that I have with that client. If I know they're going through a divorce, I can't tell her that, so there's a lot of circumstances where personal information just can't be conveyed if you know it. So, but other than that, I mean, if you know something, you have to disclose it to the buyer. Conflict of interest for buyers. Buyer acknowledges that the designated agent may represent other buyers. And right now we've all got buyers, it's like, I may have 3 buyers that want one house that comes up in limited inventory environment. Buyer acknowledges and agrees that the designated agent may show more than one buyer the same property. So we can show the same property to different buyers. We can present offers from multiple buyers, and again, it's always a challenge. You can't run and say to that other buyer, hey, this guy over here offered,
Right.
250,000. I think you should go 255, but you can work for him. to coach them through that. So conflict of interest with sellers. It's hard for a buyer agent to represent a buyer fully without, on their own listing. And so typically if we have a buyer come into an open house or call on a sign, well, for my team, those are on my listings, those are leads going to be going to you guys anyway. But, we're going to tell them, hey, we're not signing you up to buyer agency on this house. We're just going to present the offer as a disclosed agent of the seller. And so in that regard, we don't get into dual agency. Some people want it. We're okay with it. If they come back around by another one of our listings, you've already got a buyer under agency contract, and yeah, you'd have them be under dual agency at that point. It's also hard for us to represent a buyer if like I own the house or, one of my family members, I have to disclose to them that, that I'm related to them or something. So buyer disclosure, buyer agrees to disclose to designated agent relevant personal and financial information to assure that the buyer has the ability to complete any transaction. So the old saying, buyers are liars, typically holds true. Make sure your buyers are getting pre-approved and pre-approval letter in hand before you're writing offers. So leasing or optioning, that's not going to come up very often, but there is a clause in here on that says that it's treated basically like a sale if you're out leasing an apartment or writing an option contract on a house. If you get into that, come see me, because that's different territory altogether. So cost of services or products obtained from outside sources. Brokerage firm will not obtain or order products or services from outside sources without the prior consent of the buyer. So if, let's say we need a survey on a property, they may just say, go ahead and order it. Doesn't mean I'm paying for it. They're still on the hook for it, but I need to ask them, give them an estimate. Our policy always is go get an estimate, tell them what's going to cost, and then get their approval on it. So indemnification, that just buyers agrees to indemnify and hold harmless us, the broker, the designated agent, the firm, against all damages, provided no one at the brokerage firm is at fault. If you're out committing fraud or pushing people down the stairs, then I think you could probably be found at fault. Non-discrimination is pretty self-explanatory. You guys had fair housing training as part of your pre-license training. I presume they still teach that. And if people qualify financially for a house, we will sell it to them. Counterparts, this agreement may be signed in any number of counterparts. If you got a husband and wife, you got two separate pieces of paper, they can sign it. Electronic communication is legal, meaning we can do electronic signatures. Limitation, buyer and brokerage firm agree. Oh, condition of the property, big one right here. Probably should not have skipped over that. Buyer is not relying on a designated agent to determine the suitability of any desired property for the buyer's purposes or regarding the environmental or other condition of desired property. So they're signing a document that says that they didn't rely on me for any of that information. However, every time we walk through a house, what do we talk about? Condition of the property. Right. I would be cautious against, I'm a licensed builder and I still tell people, look, I didn't build this house, so I can't tell you how it was built.
An opinion, right? So yeah, look at it.
And so you want to start phrasing when you're out showing properties, phrasing those things like, hey, this may come back on an inspection report, or you may see this. Over time, you're going to learn stuff. I know more about houses than I care to, or probably should, but over time, you're going to learn more. And as you learn more, you're going to be able to help your clients more. But at the same time, you have to be cautious about like saying, oh, this roof is perfect, it'll never leak, versus this looks like a newer roof, but we should still probably have an inspector tell us how the condition is on it. So just, how you talk to people means a lot in this business. Limitation, buyer and brokerage firm agree that any and all claims and lawsuits between the parties of this agreement must be filed no more than 6 months after the date of termination of the agreement. Parties waive any statute of limitations to the contrary. The merger, you can merge the entire agreement between parties. And basically everything merges into this document. According to this, that's another one I got my lawyer working on. So agreement may be canceled only by the mutual consent of parties in writing. We can expire this early if you get somebody that's just not a good fit. For you guys on my team, we're going to put $395 in here as a broker transaction fee. Eric, you're going to want to, are you on a team or are you solo agent?
Solo.
So depending on what plan you're on, you'll want to check with Judy probably and see what brokerage fee you're supposed to be charging on that. So I think as a solo agent, it's all $395 because we kind of follow in lockstep what the company's doing, but some teams charge a little bit different. And I don't know if any of the plans still allow you to charge different either. But so
Okay.
for right now, plan on $395.
I'll look into it.
Now I would do something to this effect in all of mine, because this is the number one question I get asked is like, I thought you said we didn't owe you anything, and up there it says that they owe something. Something to that effect. Your signature needs to go on here. It's already automatically assigned Bethany, and then we're going to do that little no one there. Save that as well. Any questions on the buyer agency contract?
And that they sign right away or right when they agree to work with you typically, but it can be done at like closing if it hasn't been. Is that what you said?
Yeah, and so, you know, again, it's all in your approach and your relationship with the client. A lot of times, you know, I go out and show a few houses first, make sure it's a good fit. If they like you, you like them, approach them about getting it signed. I've worked with so many people that I know and have worked with in the past, and I never really thought about it. But you know, it's all. But if you get, you know, somebody picked up off a random internet lead, and you know, you're worried about them going away, lock them up.
Okay.
All right, purchase agreement. This is where autofill comes in handy. For some reason, it did not translate, but you can add a lot of stuff in here ahead of time as well. But in this instance, we're going to start from scratch. So today's date right at the top. Timestamps are important, especially in an environment where offer presentation time, I might go to 4:30 on this as a time. Offer presentation time, deadlines, you know, are important. Turnaround times, response times. Make sure you're putting timestamps on stuff. Signatures are automatically timestamped, so you don't have to worry about that. But anytime you're filling out documents, there's a spot, put a time in, put it in. Do you guys see that when I switch back over to the MLS, or are you still looking?
Yeah.
Okay. So I'm going to just copy and paste the MLS number in here. This auto fills us, Grand Rapids East. Broker license number, you're going to want to either jot this down, or if you're one of these really awesome memorization people, 6505-298-581. That is our broker license number. Realtor phone number, it populates the main number in here. I go and put my cell phone number in there for clarity's sake. Again, a lot of this stuff is antiquated with everybody, you know, immediately available on their cell phones now. But this listing office, that's, if I switch screens, you can get it on there. Listing office, I think, is it's Eastbrook Realty.
Let me grab this.
I noticed that the other day. Eastbrook Realty, and then I would throw their cell phone number in there too. It's interesting because we had the unfortunate incident earlier this year where one of our agents passed away. She fell ill, and I had to go into her files and look up her purchase agreements. And fortunately, she was really good at filling things out, so I was able to get a hold of her clients. It's another reason I want you to fill everything out in case you guys fall off the face of the earth. I got to be able to track people. All right, primary selling agent name. For you guys, you're going to put your names in there. On my team, you're going to put me in here below it with email. This license number thing, this is a weird glitch in the matrix that auto-populates another agent that's not even at this company. That's his MLS login. So explain to me how that got auto-populate, and I cannot change it. I've talked to Dotloop. I've talked to tech at GRAR. So I just deal with it. So your individual license number goes in there. Now, this one happens to be new construction. So if I'm writing this, I'd put this in as not receiving a seller's disclosure statement. But if it's an MLS listing and you go to documents, you can pull your seller's disclosure statement right here and download it to a PDF, then add it back to your file and share it, and then get signatures on it as well. In this environment, you want to do everything you can. So I would make certain that you're checking this box and filling this portion of it out with the date that the seller signed it to indicate to the seller that, hey, my buyer's seen this seller's disclosure statement, they're okay with it. And you know, it's just one more vote of confidence on your purchase agreement in a competitive environment. So in this instance, it's new construction. So actually, I'm going to mark this down here. Sellers exempt from the requirements because builders are exempt from that. So this happens to be, I believe, Georgetown Township. So we got to get a little bit of data off of this. So yep, we're Georgetown Township. So we need to know where the property is. Ottawa County, and then your mailing address is 8915 Lane, number 32. Denison, Michigan. Legal description is usually on here. New construction, newly platted land, maybe not. This one does have one, so you can copy and paste that. If you're unsure it's correct, always check municipal records. Same thing with a permanent parcel number. That'll be found on our MLS in here, right there. Also known as a tax ID number. We can copy and paste that right in there. Land Division Act has a paragraph in here as well. This is a condominium, so it's not even going to apply. You can't take any splits on that land. We're going to fill in our price here. This one's listed at $392,500. I'm going to give them list price. As you go, you're going to learn pricing, valuation, market conditions, which are all going to come into play on that. So seller concessions. If you have a buyer that needs help from a seller, you'd put that in here. If any, it could be up to 3% of the sale price. Maybe they only need a couple $1,000s. You'd add that in there. This one's going to be finance new mortgage. So now keep in mind, this has some teeth to it in that it talks about appraisal. So when we talk about today's environment of appraisal gap coverages, and issues associated with that. There's some wording that I use in a competing bid scenario to still protect our buyer if they are going to offer money additional on appraisal gap. So this particular buyer I'm working with, to get a conventional loan, you could fill in FHA, VA, physician's loans. If you're working with a doctor or dentist, here you'd put in 30, typically it could be 15 years. If they're conventional, they're probably 10 or 20% down. So the opposite of that is going to be your actual loan amount. 80% of the purchase price. If you're FHA, 3.5% down minimum, so you'd put 96.5 in there. Make sure you fill this section out because I see a lot of purchase agreements come over with an interest rate not to exceed best written in here. That's lazy. Sometimes it's blank. Well, this is your financing contingency. This paragraph protects your buyer if they cannot get a loan. So if we don't have this filled out properly and then they fail to get a loan, then that could have some ramifications for them getting their earnest deposit back. Now, if we fill this out properly, current rates are 3.5. I may go 3.75 on here as a cap, and you're going to explain that to them. Say, hey, look, this isn't the interest rate you're getting from the bank. This is a caveat in case you go to the bank tomorrow and apply for a loan and they come back and say, well, your credit's a little dinged. I can only get you 4.25 and the payment's going to be X and they don't like the payment. That's their out.
So this is assuming they don't have a pre-approval?
Well, no, and they could have pre-approval or
I guess
pre-qualification,
the
but when
interest
you
rate
make,
doesn't
yeah,
lock,
you
right?
don't
So
lock an
that-
interest rate.
That's true.
So here's an example of this. I had a couple guys that we were working with. They wrote an offer on a 4-unit. They were pre-approved on a 4-unit down in Kentwood. This was several years ago. We had them pre-approved with this lender. They went out, shopped a loan, and got a lower interest rate, but that lender then wouldn't give them financing because they didn't have a large enough down payment. So they went back to the original lender and said, hey, we're back here, give us our loan. And he goes, sorry guys, rates have gone up. They've gone up by 0.5%. Cash flow model on the apartment building didn't make sense anymore. They couldn't make any money on it. So they wanted to back out. And I couldn't get them their earnest deposit back because they made application for a loan, decided not to go with that lender, and then tried to reapply. Well, you've got a time in here that says you're going to apply for a loan. Again, in this type of market, you're going to probably put 5 business days in here for final application on that loan.
I see.
Now, in the event of FHA repairs, I would say in this environment, minimally, we're putting $250 in here for VA and FHA financing. Pay attention to the quality level of the house. If you see a lot of peeling paint, it's kind of decrepit. If it comes back at more than this, you're kind of renegotiating anyway. But this just says, hey, if you got to go scrape and paint a windowsill or change out a GFCI outlet or put up a handrail, you can still get that done. So. And we'll want to check one of these boxes again. You're appealing to the seller, so a buyer should agree in this type of market to authorize a buyer's agent to obtain information from a lender regarding buyer's financing and consents to disclosure of information. So always check that box as well. Now you have other financing options here. You have a seller financing, which they can be a land contract holder or just be a purchase money mortgage, in which case they're the bank and they just issue a mortgage. Very rare in this market, you're going to be doing these sorts of things. Higher interest rates, slower sales. If you get into a land contract scenario, come see me. We'll talk through it, work through it. There are things as equity assumptions. I don't even know if I've ever done an equity assumption in my entire career, but it's still on here. So I used to be able to assume mortgages, and very few, only VA loans are like the only ones that are assumable anymore. So, all right, your contingencies. If you don't have a house to sell, first time buyers, you just mark this, means that there's no other real estate tied to it. If you have their house already under contract, you can do this. This is kind of the next best level, meaning, hey, we've been through inspections, financing is all lined up, but it still needs to close at, 123 Main Street, you type that in there. You have to furnish that contract with this purchase agreement though. Now, if they have a house to sell, like let's say I list a house, John's doing the open house, and Bethany comes in and says, hey, I want to buy this house, but I have a house to sell. You'd have to mark contingent upon the sale and closing. There's some ramifications that go along with that. There's, an out if the house doesn't sell. Sellers are less likely to take these types of offers in this market where somebody else is coming in non-contingent. So, but if you've got the ability to go non-contingent, do it. There's ways to do it, even if they do have a house to sell, but it carries risk and there's or costs money. So if we mark this, then you'd put that property address in there, but you'd also have to put a closing date in there. So, today's February 2nd, we're going to get the house listed next week. And let's just put March 31st in there as a closing date. Now, can't do a right of first refusal with these types of contracts. The board doesn't allow it. Could end up meaning that the seller pays 2 commissions, because if you try to write a first refusal in there, and Bethany has the ability to remove that contingency, and somebody else comes along, writes an offer, they've got a full price, full term offer, technically they're due a commission. Doesn't happen very often, but the board just says, don't do it. Now you might have some luck getting them to take the house off the market for 2 weeks in order for you to get the house sold. So you could add in language in here that says, seller will report pending until, let's say 3-122, gives me 4 weeks to get the house under contract. So then we'd be delivering a purchase agreement and we're
I
going to
see.
this status here.
So after 3-1, they can take whatever off they won't. I mean,
Well, and if you don't have language in here like this, then it says seller, specifically right here, seller will have the right to continue to market the seller's property until the buyer enters into a binding agreement. So that house will stay on the market until you deliver a pending contract.
I gotcha.
Fixtures and improvements, big laundry list of things that are included with the sale of the house. If it's listed here, it should stay. You're going to list your appliances in here, microwave. Now, again, if we're trying to protect our best interests of our buyers, microwave, stove, refrigerator, things like that. If I could type, that'd be awesome. Now, possibility exists. You see a nice shiny stainless steel LG refrigerator. At the time of showing, you show up for your walkthrough, day of close, and some rusty almond, 1970s Kenmore that's on its last legs. You could get real specific and put in there make, model, numbers. I think in today's environment, there's enough video and physical and photographic evidence of what's in the house,
Right.
that you could just say appliances seen in-house at time of showing. If you're in a new build and it's not in the house yet, you could add language in there to be determined, to be agreed upon by buyer and seller, or builder and buyer, whatever. So does not include, maybe you see on the listing agreement or in the notes on the listing itself, the swing set in the backyard doesn't stay. Well, you'd specifically put that in there. Maybe there's something you walk through and you didn't want. Maybe there is a kid's swing set that's old and decrepit. You want to get it out of there. You could add that too, even if it's not a reserved item. So. True story about how this comes into play. We had a buyer, this is many years ago, we wrote an offer over on northwest side. It wasn't Maple Row. I'm trying to remember which street it was on, but we had in there all window treatments. Buyer is a single guy for some reason. I remember him noticing this stained glass valance that was above on the kitchen window, above the kitchen sink. He goes, "Oh, I really like that. And I'd like that to stay." I don't know. Not a big deal to me, but we went over for inspections. Seller was actually there. She came out and said, "Well, my mom or dad or somebody made that stained glass piece. We're taking that with us." And he just shot me a look. And I was just like, "Hey, don't worry about it. We'll deal with it later." Called the listing agent. I said, "Hey, I think we got a problem." He said he wanted it. She said she's taking it. They gave us 4 oak bar stools, a chest freezer, a steel case desk, and all the liquor behind the bar in the basement as compensation so she could take this stained glass piece. So,
And all because the realtor didn't put it in here.
well, I wrote it in that all window treatments were specifically included. And so window treatments are kind of funny. And so the rule is like if it's bolted to the wall or it's a blind that's screwed into the framing, it stays. Curtains can be taken down and those window treatments would typically go. So when in doubt, spell it out. If there's any indication that, because that's where we get into issues with buyer and seller at closing or after closing is, "Hey, we thought we could take this," or, we couldn't or whatever. And so if you have
This
any
actually
doubt,
happened on my house currently.
what's that? What was that, Eric?
You're on mute. You're
When I currently bought the house that I'm in now, we put in the thing that we had to have matching washer and dryers that they were being bought for us.
Mhm.
And to match our kitchen appliances. And then when they tried to give us our washer and dryer, it came in at like the basic white one.
Okay.
And it wasn't the stainless steel matching to the kitchen. So like my real estate agent had all that stuff right in there. Henry Steffes, if you know him, Hank.
Yep.
Yep. So he like made sure all that was in there, and then like gutters around the house because I bought a brand new Bosscraft.
Okay.
So
Yeah.
we had to work everything in. They had the big negotiations with the builder.
Yep.
So
Got to watch them. So that's our job. That's part of our job is to make sure that what we put in there stays in there. So assessments, you're going to typically mark. This is another thing I've gone round and round with my attorney is what this actually means. Because it kind of, both of them to me say the same thing. But if you have like a municipal natural gas assessment or sewer that went through in a development, and there's assessments can be paid up front, they can be added to the property tax bill. And so by checking this box at the top in paragraph 12, you're indicating you want that all taken care of. If you check the second one, then you're assuming the payments beyond that. So I bought a piece of property down on a lake, south of Gun Lake, a few years ago. The sewer had gone through. Gun Lake Sewer Authority was already there. And there was like a $6,000 assessment on the property. I assumed it. Like I made my offer. I said, "Look, I'll continue to pay this or whatever." And then when I sold it, I made them take it too. So
Gotcha.
typically you want stuff paid off though. So that would be the top box. So property taxes, my recommendation is we always write calendar year proration. I've done different proration, like no proration up here, had delays in closings, and then it really gets sticky if those tax bills are issued. So calendar year is typically the fair way to do things. Keep in mind that without giving you a big property tax lesson today, taxes are billed twice a year in the state of Michigan, typically by the township, and they cover January 1 to December 31, no matter what day those are billed. So around here, property tax bill comes out July 1st. That's January 1 to December 31 for proration. And then there's another bill that'll come out this year in December, but that's also a December 1, 2022 to December 31, 2022 tax bill. We're going to save the rest of that for another day. So Well and septic. Now this has just been updated and I can't even tell if this is not the new version of it. So we're going to be going over a new version of it. If you get into well and septic right now, reach out to me or Coach Cat on this. Each municipality is different. Ottawa County is different than Kent County. It's different than Allegan County, different than Newaygo County. So depending on where you're writing the offers, there's going to be different and different communities do it differently. So your first deal, you want to get into well and septic, stay tuned because we're going to have more on this when the new forms come out. But right now it says the seller has to pay for it. I always just automatically, this is one thing you're going to want to remember in here, seller to provide recent pump card and inspection from licensed sanitarian. That's the one way you're going to make sure that your buyer's protected and get a full report on this. So the new option is for the buyer to pay for it. I don't know, I struggle with why they did it. I don't necessarily agree with it, but I got to deal with it. So, all right, inspections. Now, inspections, there's no such thing as a licensed inspector in the state of Michigan. Inspections can be done by, anyone, including the buyer. We recommend that they use somebody that's certified with either ASHI, trying to remember the other board, but there's national governing boards that teach protocol on how to inspect homes. And buyer has that opportunity. Typically, that's 10 days. This is also changing. You're going to learn that coming up. That because of this environment, we're seeing inspection periods shortened down to 5 days, pass, fail, what have you. Basically, it says this: buyer can go in, do their investigation on the house, and walk away for any reason. And if you make a counter offer in the form of like, hey, I want a new roof on this house, seller can say no and terminate the deal. So we're always at risk in an environment in this type of market of, hey, be careful what we ask for. Now, if the house has termites, mold in the attic, the roof's failing, and the foundation's crumbling, and they want to walk away, that's fine. Have them run away. Experience will tell you that, you probably should have pointed a few of those things out, maybe going through the house, but hey, maybe there's, I don't crawl in the attic and know if there's mold up there. And I know how to look for termites, but I'm not a termite inspector. So if we see stuff, maybe we can avoid that. But in the event that you've got just a bad house on your hands, you can ask for repairs with the understanding that the seller can walk away. If the kitchen faucet's leaking and the buyer wants that fixed, and there were 12 offers on the property, I would advise them not to. So they're probably going to lose the deal. I had $1 million house under contract. It was $1.1 million actually in East Grand Rapids 2 years ago. It was not an old house. The furnace needed a tune-up. It was leaking some water around the condensation lines or whatever. Went back to the other agent and I said, hey, look, they're paying $1 million for the house. I go, you think we can get the furnace tuned up? Mm-hmm. And she goes, yeah, but I wouldn't write that up. She goes, I just got a backup offer for 6 figures more than yours. And she goes, oh, and she did me a solid favor, because if I had sent that over, and I think the only reason she did it was because we had a solid buyer, and this other buyer she wasn't sure that they really had the cash for it. And so we dodged a bullet there though, because I could have said, yeah, you're paying $1 million for a house. Let's go right up. At that point, I'm just calling the furnace company and getting it taken care of on $1 million sale. So,
Yeah.
But she did us a solid by telling us about that. Now this checkbox here waives all inspections. So you check that box, there's some seriousness to that, and we better be having a conversation with our buyers about what that means. It means you cannot go in and do an inspection. It means you are buying it as is. And even though the seller has an obligation to disclose to you, it's hard to prove in court, even if you find out that they didn't disclose something to you. So
Are there people checking that boxes and then like getting a warranty for a certain amount of time to try and like maybe cover some of that?
Yeah, you can. I would think long and hard about that because warranties have coverage, not guarantees. And, we lost that house I wrote on Thursday last week. We lost to two other offers, both waiving inspections.
Wow.
It was a 20-year-old house, newer furnace, newer roof, newer water heater, seemed in really good shape, but it just, we went five days past fail. And there's so many agents out there right now. I've got a pending court case as the broker here on one of our listings, where the buyer waived inspections. I don't think it's going to go anywhere with us because we didn't do anything wrong, but attorneys want, everybody involved to pay the piper. And so, ultimately, I think it's the buyer's broker that's going to probably have to pay something because they're the ones that wrote the offer for them, not us. So
what happened? Something happened then? Something went wrong?
yeah, water in the basement,
Gotcha.
didn't have inspections done.
Right.
Claims,
So
wants to sue the seller, wants to sue us, wants to sue the buyer's broker, everybody gets sued at that point. So, but we're fine. I'm not worried about it. So
with that box being checked, he still has like that ability to sue. I mean, it's like,
if under state law, and it's hard to prove, but if, let's say, ABC Waterproofing Company had gone out there and said, yeah, you got water in your basement, here's an estimate for $20,000, and buyer moves in, calls ABC Waterproofing, and he goes, yeah, we're out here 2 weeks ago, we told the guy he had water in the basement and he should remedy it, and your seller's disclosure statement says, I've never had water in the basement, that's where you can get caught up on that section. Right. So again, when we're advising our sellers about disclosure, say it's better to disclose everything now than to pay an attorney to tell you the same thing, after the sale. And as a buyer's agent, it's hard to prove. My first sale, 2001, closed in May. My wedding anniversary is in May. We were out to dinner, kind of celebrating my first closing. Pouring rain out, like 4 inches of rain that night. I get a call from the buyers.
oh no way.
My first sale. There's water in our basement. I'm like, I should have just quit right there, So, but I didn't. And but it's hard to prove. I went to a broker. I was like, what can we do? And he's like, well, the contract's between the buyer and the seller. And if there was no prior knowledge of it, or it was noted on the inspection, and it's still a buyer beware market,
Right.
And I went into this particular house that is under question right now, and there's no way you couldn't tell there was water in that basement. So
right. But then, so with that checkbox being signed, then we send off this purchase agreement to the seller.
Mhm.
That like there's no like 3-day period of inspection or 5. It's just we're moving on right then and there.
You're moving on.
Yeah,
Yep. So municipal compliances, this is antiquated here. City of Grand Rapids used to have sidewalk compliance. They don't anymore. Smoke detector ordinances still exist, but typically are only inspected on rental properties. Certificate of occupancy would come into play with new construction or in the event of condemned housing. And that's really the only two situations you'd have that. So title insurance. Now, the title company plays two roles. One, they insure the deed against defects. And so your lender is going to require on a finance deal, a policy also. So they play the role of insurer of the deed, and then also as escrow agent, because we're not an attorney state of Michigan, you close out the title company. So we hear this, hey, I'll order title work. And so this paragraph says, hey, you've got to order an expanded coverage Alta policy of title insurance and the amount of the purchase price. And you have 10 days to get that done and ordered. And if the buyer objects, they've got a certain amount of time to respond to that. Now, title defects are typically fixable. It's a matter of whether or not it's worth it. We had a property up near Baldwin a few years ago. The title report came back showing that it had sold at a DNR sale and a tax sale within 2 years of each other to two different people. And nobody, I mean, this was like 50 years ago and two of them are in Detroit. And it's like, how do you, these people are dead. Like there's no way to, the lot was $12,000. It's not worth hiring an attorney to spend $20,000 to quiet title on that. Just, most things aren't that involved that you're going to see in residential real estate, but things exist. I mean, I see all kinds of stuff, different things that need to be fixed. Read your title work when it comes in, go over it with your buyers, say, these are the conditions. It's typically going to be pay off the mortgage. It might be a home equity line that nobody remembered or something like that. But just make sure that you go over your title work with your buyers. Surveys the same way. You can select a buyer or a seller to pay for it. In this market, you're probably checking buyer. A lot of people are checking no survey these days. And again, another contingency. I don't like to see waived, but now with overhead GIS systems, satellite photos with lot lines, things like that, it's a safe bet. A property in the city of Grand Rapids is probably where you think it is. But if we're buying 20 acres out in Owego County, kind of want to know where those lot lines are, and I'm probably going to want a survey. So home protection plans, this just indicates that those home warranties are available. You could put in here in the exceptions, the seller to provide 1 year home warranty, something to that effect. If they're offering it, something like that. So, all right, closing date. Again, we're trying to appeal to a seller now, maybe in a competitive environment. How soon can we close this? What do they want to see? Again, a lot of times I'm picking up the phone, but talking to the lender last year, some lenders were having troubles closing within 30 days. So you try and stretch that out. If it's FHA or VA, I'd plan on 45 days. But here, something like this, March 11th, probably be fine. That's your contract date. So if it doesn't close by that date, you need an extension. And if it doesn't close by that date, that goes back to my East Grand Rapids property that we had under contract. We had the buyer getting his loan through a kind of a private banker in New York through Citibank, because he worked for them as a finance guy. And I called this lender. I said, look, you guys are kind of non-communicative on this. And if this doesn't go through, then seller can say no. Like, we had to close that day. Again, 6-figure better backup sitting in the wings. We don't make a March 11th closing date. Seller can say, hey, we're selling to somebody else now. So most times you can get an extension. If it's going to be a couple days, you run into some delays with financing, but just something you're going to have to talk through, and there are sellers under no obligation to extend. Now, everybody seems to think you get this magical 15-day window of an extension if you can't meet a closing date, but there's some stipulations to that. It's only in the event of title defects, survey problems, or lender required re-inspection on repairs. So FHA says, hey, fix the peeling paint, but I can't be out there till March 12th. Then you've got an extension. If you got a title defect, you got 15 days to fix it. Survey defect, you got 15 days to fix it. It's not a, hey, I need another pay stub to show my pay raised in order to qualify for the loan. Right. It's not a 2-week grace period, carte blanche. So just keep that in mind. Possession, again, right now, as much as I hate it, possession is typically after close on occupied homes, 30 days free of charge for the seller to stay there. I'd like us to encourage us to use there's a possession after close document that is in there in our buyer docs that spells out a lot more than just this half a paragraph here about what possession after close means, because you're creating a tenant landlord relationship between your buyer and your seller at that point. And seller's a tenant. I just took a call yesterday, closed on the house, got about 3 or 4 more days of possession, and the sewer line collapsed. Whose responsibility is that? Mm-hmm. So an old clay pipe, it's our seller. Buyer waived inspections, and they're not going to be happy because it's about $6,000 to $8,000 to fix it. But if I'm the seller, I'm throwing the keys on the counter and I'm walking out. So, but typically you're going to put a time in there, 5 p.m. on the 30th day after completion. And right now, free of charge is 0 occupancy fee. Now, you can ask for damages if they don't get out on time. Typically, I would put a minimum of 200 a day in there, depending on the, now, again, this judgment call, like you go through a house and it's just rat nasty, full of possessions, and you don't think they're going to be out of there in time. Maybe you put some teeth behind that and it's $500 a day. It just depends. Everybody has different circumstances. Some get out on time, some don't. Usually there's a little negotiation that goes on beyond the closing if it drags out. So, oops. Adding my timestamp like I'm supposed to. All right. This goes on to say how that's handled. Seller pays utilities, buyer maintains the structure and mechanical systems of the property. However, any repairs or replacements necessitated by seller's misuse, abuse, or neglect of any portion of the property will be seller's responsibility and expense. So that, a collapsed sewer line to me is not misuse or abuse. And so that is the buyer responsibility. So should be trash and debris free and broom clean condition, remove all personal property. People always leave behind old paint cans and boxes, and I get those calls all the time. That's why a final walkthrough can be important, but if they've got 30 days possession, doesn't really matter, so again, sometimes it's just easier for me to call the trash hauler and say, we'll have somebody over there at 2 o'clock, pick stuff up and get it out of there. So that's why I own a pickup truck in case I ever have to do that kind of stuff. So, all right. So we need to create a deadline. If there's a published deadline of, 5 o'clock today, I'd probably give them till 9 o'clock tonight. You're not going to get an answer right at 5. This holds teeth. If this expires and you don't get a response, buyer can actually go buy another property too. So make sure you're talking about that deadline. Maybe you got 2 houses you want to write on. One has a deadline today at 5. The other one's deadline at 5 tomorrow. So you make sure you're on this one before you move on to the next one. First rule, all 3 of you guys write this down, carve it on your foreheads, whatever you need to. Don't write 2 offers on the 2 different properties simultaneously with the same buyer.
Okay.
You could be contractually bound to buy 2 properties. And if your buyer can't afford it, it's just not good to do that. Pick a property, write on it, pursue it. If that one fails, go find him another one. So I see it happening. I don't like it. Go write 5 offers on a weekend, see which one sticks. It's just not good business practice. It'll come back to bite you at some point. So maybe I put 5 p.m. in here for tomorrow. Your earnest deposit amount goes in here, usually about 1% of the sale price. What was the price on this one? 2 something. So maybe $3,000 roughly. You're going to write Keller Williams if we're holding it. Otherwise, if the title company's holding it, spell that out too. But in the event of maybe a HUD home or a builder, maybe they've already indicated who needs to hold it. Be aware too, we have 3 Keller Williams offices in town and 1 in Holland. So make sure you're putting Keller Williams Grand Rapids East as the brokerage that's holding that. Now we have the Earnest app. You can collect it electronically and it goes into our account. You cannot wire funds to our bank account if we're holding that. So we do not accept wire transfers here. It's a wire fraud protection thing. We'll get into all that later, but just know that Earnest app or physical check at the office are the 2 ways to collect an earnest deposit. So we don't take credit cards. We don't take cash. Make sure you're getting a check and I mean, it's a challenge. Like some young people just don't have checking accounts. If you still have a bank account, your bank will issue you a check, cashier's check, or just draft bill pay type thing. Now, this contract says something different than what our company policy is. So this says that we're collecting this within 72 hours of the effective date of the agreement. So it'll be applied against purchase price. Earnest deposits not received within 72 hours of the effective date or its return for insufficient funds, seller may terminate this agreement until such time as the earnest money deposit is received. So that's contractually how it works. Our company policy coincides with state law. Once we collect it, we have to have it in the bank within 48 hours. And so our company policy is if you have binding contract, it's got to be here within 48 hours, either via earnest or paper check at the office. If it's going to be late, let me know. If you don't collect it, obviously the seller has some options there, but if you can't get it, the rest of that paragraph goes on to explain how that's held. So you're going to want to tell your buyers that we hold it. It's a non-interest bearing account. It's their money. It stays their money unless they're in breach of contract. If they back out because of inspections or can't get financing, they get that back. But if they call in the day before closing and say, hey, I'm moving to Omaha, Nebraska, I don't want the house anymore, then they're in breach of contract and they're probably not going to get that back. And I've got to negotiate through that for them. So if both parties can't agree on how it's dispersed, then I send a letter saying, hey, Mr. Buyer, you screwed up, or Mr. and Mrs. Seller, we really think that, the buyer's in the right here and they should get it back. And if they still can't agree, I've sent a letter to them with certified mail. If they still contest it, I just file it with the court, and then the loser pays the court costs. Never court over earnest deposit. Don't want to. Doubt I ever will, but it's the only way to really release it if they just dig in their heels. Usually on $2,000-3,000, somebody recognizes, yeah, I'm in the wrong, or it's not worth fighting for. You get into bigger deals though, tens of thousands of dollars earnest deposit, people are going to dig their heels in and fight. So professional advice is going to tell you that we've got the buyer should seek legal tax advice from those qualified professionals. Disclosure of information just says that we're going to report the sale to the board. So you have comps to compare your next sale to. Other provisions, this is where you can get into anything like, now again, we're going to have a change in the purchase agreement. So this is going to be antiquated in about a week when I reteach this to you guys, but this was always my standard go-to in here. If you have an escalation clause in that you want to add, use the escalation clause form, but you can add, hey, this addendum attached as part of this. Maybe you got a list of personal property that's included as part of a bill of sale you can attach to it. This is where your opportunity to, and again, you're not attorneys, so don't get too fancy with your wording. If you get into something really squirrely, let me know. But if seller to repair, picket fence to standard and consistency with, the rest of the fencing, or maybe they got to finish some basement bathroom or something, you can spell that out in there too. So mergers and integrations, again, it talks about the ability to sign separate documents and be legal, faxes and electronic documents, a wire fraud warning on here, another date and time stamp. And then your buyer signs it. No one there. Again, you can have them fill this stuff out if you want. It's a good idea. Or seller's response comes back as written, then you've got a binding contract. So the effective date of that contract, like your 10-day window for inspections, would be, this came back today as written, starts tomorrow. If it's checked here and signed.
So it's always the next day.
It is day one.
Is day one
Yeah.
the next? Okay. So they sign in the morning. of the next day doesn't start till.
Yeah, so if they accept this tomorrow morning, my day one for inspection window, the effective date of the contract it would be tomorrow, but day one of 10-day inspection window would be the next day. So if it's counter offer, they're going to spell out the term sale price to be X, yada, yada, yada. We want to close in April, whatever. They're going to give you a time window. Maybe they're going to put it in here. We want an answer by Friday at 4. They sign it. Now you only have a counter offer, and it says right here, seller has the right to withdraw this counter offer. So again, in this environment, get your counter offers presented, get them signed, because if you don't, then somebody else could still come in, write an offer. They could say, hey, we rescind this counter, and you're left holding the bag. So they're going to indicate whether or not they're going to agree to inform you of any changes, which they should. Notice to seller, consummation of the sale, it's just a notice to them. They still have to pay off mortgages, things like that. Listing agent fills out their info here, they sign it. There is a mark box on here whether or not they're a US citizen, and that pertains to the seller from a taxing standpoint. So if they're not a US citizen, they could be subject to what are called FERPTA taxes. So we get a counter offer back. As soon as you get a buyer's signature on this, then you've got a binding contract again, and the seller only needs to sign this as an acknowledgement, in which case you still, as soon as Bethany would sign this, I've got a legally binding contract. So, and that's why those date and time stamps are important. She signs this at 5:03 today, boom, we're good, and we're moving forward. So seller can sign this here as an acknowledgement. You would have your buyer sign it if they accept it as written, but the buyer signature is not needed on this line if that as written box is checked. So it's kind of like as written, binding, counter offer, binding, and acknowledged. So any questions? You guys are going to have questions on purchase agreements. I think what we're going to do today, I've got to jump on another Zoom call at 5:15. And I need to grab something else to drink and make a phone call here real quick. So I think we're going to call it a day for today. And then I'm going to try to continue to do these on Wednesday afternoons with you guys. And then we'll cover the rest of the buyer docs next week. And in the meantime, if you have an offer you need to write, obviously get with me and we'll get you through the rest of them too. So
Thank you, Jason. I'll try and be here Wednesday, but I will be in Weddington for my other job. So
hey,
I'll
no
try.
worries. If you can get on, great. If not, and check the calendar. There's training every month. So, and you've got the resources around you. If you need help, let us know. So,
Thank you so much.
all right. Sounds
Yeah,
good.
thank you very much. This was very helpful.
Good. I'm going to stop sharing this now and hopefully stop recording. So if you have any questions, let me know. And otherwise,
Okay, great.
we'll see you later. Thanks, guys.
Bye, thank you.